Well, I must add that we at CEPS, we organized a seminar on online privacy in July, and we had from Alan Rowell from the Board of Civil Liberties in the US, we had another call, and also Alain Brun from the European Commission, DGJLS, that deals with privacy issues, where they agree that a roundtable on global privacy issues could be a good idea. And also we, as a think tank, are actually working on a forward-looking basis to see whether such a thing could be set up. This will be global, not just US and EU, like many initiatives that we have. And I wonder whether technology could be one of the bases for establishing such principles. And I remember, for those of us that experienced the birth of the World Wide Web like we know it today, I remember that cartoon that we saw on the New Yorker that was very famous, where there was a little dog, a little pet, surfing on the internet and telling his pet friend, and you know, here is great because nobody knows you're a dog. No, things are quite different today, probably, and the PET is another thing now. PET is an acronym, it means Privacy Enhancing Technologies. So I've seen that Peter Hustings was mentioning this too, and I wonder what is your, the role you think, I think the Commission has issued a communication on Privacy Enhancing Technologies on May 2nd, I think, this year, and with stating the intention of probably developing and also further standardizing privacy-enhancing technology and certainly promoting their use. I wonder whether, you know, the three speakers in the panel, what are your feelings on this, especially on these three verbs, developing, standardizing, and promoting, whether you think this would be a good idea?
Here's the idea. Technology is not to replace legal solutions. And the legal solutions cannot be effective without technological elements. So it is really a means to make legal principles protection more effective in a highly technological environment. Privacy-enhancing technologies, in my view, would be already required in the most challenging environments like e-health, e-government solutions, identity management systems. I cannot imagine those systems to function well without substantial amounts of privacy-enhancing technology. In fact, if you analyze the directive as it presently stands and national law, it is saying that there should be data security measures to ensure lawful processing. And in these environments, not just data theft or breaking in, but just ensure lawful processing. If you take that serious, it requires the technology not only to facilitate, but to ensure that it only happens the way it is legal, not in a formal sense, in a substantive sense. That is everything relating to collection, retention, access, etc. Now, what the Commission is doing is it is highlighting this need. It is probably doing very useful work in standards so that it could be used. I think we should see this take off in one of those areas which I mentioned. And then I cannot imagine that in the digital age, online, what Peter is describing, Peter Fleischer, is doable without this kind of technology. So in the future schemes, the context is changing, technology is changing. Of course, this has an impact. And to make privacy protection effective, we need to develop the tools, legal and technical, that those who are responsible can act and make a waterproof, may I say this, a waterproof solution, and then present it. And this is what I have. And the verification to verify the architecture, the example I mentioned, would be most welcome in that context.
You know, it's true that one privacy advocacy group got worldwide headlines when they called us the worst in the world or whatever they said. You know, I remember when I was a kid and one day I wanted my mom to make me cookies and she didn't, and I said, "You're the worst mom in the world." You know, it just, you want attention, right? And boy, did they get it. You know, boy, I mean, I can't go anywhere without being reminded of that. I've subsequently apologized to my mom, so we're okay on that. Yeah, I did. So on the question about technology, obviously, you know, at Google we believe that technology is going to be the solution to a lot of these issues, right? I'll give you a couple examples. You know, if you take communications that have gone online and become permanent in email or in chat in a way that they never were in the age of the telephone, the content of your communication, there's a permanent record and can be used by people. You know, in our chat product, we now have a go off the record functionality, which I think is completely cool. It's a privacy enhancing technology. You click a button, the person you're chatting with cannot have a written record of your chat. That's, to me, a pet. That's exactly what a pet should be. Now, we're also thinking about, and we're well underway, to thinking about a digital dashboard. And picture this. It's a world where on your computer, you can see every single thing that Google knows about you and control it. You can say, yes, keep this and use it for this purpose. No, don't keep it. Yes, keep it, use it for this purpose, but not that purpose. Now, there are a lot of people who will want us to have information because we can personalize services to them. I mean, that already exists in some very basic ways, right? You log onto a service on the internet today, and it knows you're in Belgium, not in Argentina. That's kind of useful in terms of the kind of content you get, not to mention the language you see the content in. But imagine a much more sophisticated and personalized version where the systems can remember all the stuff you did. You can see it, and you can say, remember this, remember this, remember this, because I want my stuff personalized. In a world where there's already over 10 billion pages on the web, how do you get people the right stuff they want? And the world will soon have 20, 30, 50 billion pages, and the challenge becomes harder. So I think the privacy-enhancing technology solution is some kind of digital dashboard where you show people everything and let them choose everything. And there are a lot of the elements of that in place at Google, and more will be over time. You know, so just one final comment on retention, because I can't let this go without clarifying one thing. You know, data retention obligations for companies are not just about the directive that we call data retention. And I know that sometimes in policy circles, we use that as sort of shorthand. We always mean the data retention directive. Companies have to keep things for all kinds of other reasons, tax reasons, accounting reasons, because your customers, like your advertisers, might come back to you and say, gee, you just charged me 10,000 euros, show me why, right? You have to have records. Maybe I should have stopped using the word data retention and start using the word record retention. I don't know. It's just, it causes endless confusion and misunderstanding about that point. So I just wanted to clarify that. And then the final observation is, and we haven't really gotten into it, but you know, third-party data protection would be very helpful to a company like Google. I mean, remember, we're a company who are protecting our users' information. We are not there as a repository for the security and law enforcement agencies around the world. We will meet our legal obligations, but we would like a framework that's very clear and that doesn't have all of the built-in ambiguities that we have today. So.
Well, sorry. Yeah, because concerning the pets, I'm happy to hear this digital dashboard idea, because I would love it, I must admit, in terms of not because I could choose what you actually would do or what you don't do, but because then I would know what you know, and that would be the interesting point for me. But again, to use all these issues, I think there are two problems concerning pets. I mean, nevertheless, I believe they're right, they're good, they should be somehow promoted and put into place. But there are two things. I mean, it's the awareness and it's a knowledge of public. I mean, they have to know how to use it. It mustn't be complicated. It must be something really simple. And it must be as simple that politicians also understand it. That's the point. I mean, because, really, because in general, we have seen, especially when it comes to privacy enhancing technologies, and if it's something like simple as cryptography I was talking about, in general, you know, politics do not want to force to help people to do this. That's a problem, because it comes in conflict with their interest in security. Maybe to be available to retain data if necessary, to have access to data if necessary. And I mean, you as a company, you had your experiences with governments trying to access your databases and so on. And then we will see that this is going to increase, and certainly, I mean, in political terms too, we've seen the attacks, for example, against Estonia, where somebody from outside is trying just to somehow work on government service or to hit them. We've seen German government service being attacked by allegedly, I don't know, somebody trying to shut them down, and so I am a little bit afraid, and this is something where one would have to work together, is that politics could be the ones in general trying to avoid to have too enhanced pets, because they could sort of turn off the tap they actually want to get the water out of. So that is, I think, what one should work on.
Thank you. I'm Erik Josefsson from Electronic Frontier Foundation. I would like to ask on an issue that was mentioned by Mr. Hustings on liability. EFF is currently suing AT&T for handing over customer data to the US government. And I'm not asking you to take sides in this case, but is there any general comment you can make on liability? Is the corporate world interested in enhancing liability, or do you want to go the other way?
Let me make a couple observations about law enforcement requests. And first, they're very broadly speaking, there are two categories. One is the very narrow request. I'm investigating, let's say, email account XYZ because I think they were distributing, let's say, child pornography images to another email account. And you get a valid legal order for specific things relating to a specific account. And those tend to be answered on a fairly routine basis. Let's not assume that this is just a US question. It most certainly is not. And then you get a very different type of request, and they're much rare. We've also gotten one of those, which is a very large request for a data mining exercise. And we had one of those. It was from the US Department of Justice that came and asked us for billions, I say with a B, of pieces of information, to which we said no. Interestingly, a request had gone to 34 other internet companies that was never made public. It only subsequently became public that the requests had gone. So I don't know what they were asked for, and I don't know what they provided. But we challenged ours in court, and we won. Basically, the judge said, no, we are not going to compel Google to hand over a single query to the Department of Justice. I just want to point out that there are two very different types. Let me point out one other thing. From the point of view of a company, it is very hard to know what is valid legal process. As lawyers, most of the room are lawyers, it's hard enough to know in your own country as a lawyer what that means. It's even harder when you're operating in many different jurisdictions. And let me point out, it's even harder when you leave the rule of law countries. What does it mean when you're not in a rule of law country? So all of those are issues that we have to confront practically with a strong bias to a very closely scrutinizing any legal order. And if there's any ambiguity about its legal validity, we do not respond until that ambiguity is clarified. That's our bias. Other companies have the opposite bias.
Your question has two sides. One side has been answered. You mentioned that ETF is presently litigating. EFF, sorry. I mentioned this point in the context of, say, accountability, and it doesn't exist without responsibility and under circumstances liability. If accountability is used all the time and the word liability is not mentioned because that is dangerous stuff, it's not serious enough. So that's my first point. But in a more practical point, under many national legal systems, it is a legal requirement that someone acting in court is protecting his own legitimate interest. In a case of data protection, that means that a data subject has probably a difficult task in taking on a big problem. It would be helpful to bring these interests together. That could be in consumer union or foundations of general interest, special action rights. It would also be interesting if a commercial company, which has a legitimate interest in protecting the privacy of its clients or its employees, would be able to go to court. Then we have better checks and balances than presently. That's the idea. So that phenomenon itself, I welcome. I don't comment on the case itself. That's obvious. But you have further comment.
Let me just see if there are other questions on the floor. No, so we're about to close this, and I just a comment on what you just said. I think there are many areas of law in which the difficulty in detecting all the violations, or areas like the internet, like where the possibility of mapping all the behaviors has become so difficult that a number of additional tools are needed. You were mentioning basically a tool like representative actions or something like this. And this is what is happening, for instance, on competition policy as well. I think that's one of the reasons why, enhancing representative actions could be an option in order to build a second pillar of enforcement. And the third one is technology too. And it's from the very early writings of authors like Larry Lessig, for instance. The code as law, as something that becomes very important, and if it's a support to enforce and detect principles that are enshrined in the law. So I think that this is one of the key messages I think that I'm taking home today.
Provided the code makes sense, of course. If it's the wrong code, it's
exactly. And it's on the actual code that I think that a lot of debate will take place in the future. So this the debate will be over today, but the debate continues also. But first on Google's public policy blog, but also we at CEPS, and also hopefully teaming up again with Google and with everybody who wants to team up with us from the industry, and possibly also with other authoritative speakers like we had today. We want to continue this debate because we think it's very important for the future, not only of users of the internet, but also in terms of competitiveness, in terms of business environment, in terms of effective and better public policy making as well. So thank you for participating to this event. Thanks to all the speakers, and it was a great pleasure to have you here. And I think you will still have demonstrations from all the Google stuff on how the personal search, the book search, and the web search works. And you are, invited to come to the next room and continue this meeting. Thank you.